The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Four cases will be submitted this morning. Those cases are Gary Pettit versus Iowa Department of Corrections. Second case is State of Iowa versus Christopher Ryan Roby. The third case is in re the detention of Jeffrey Anderson. And the final case is Iowa Supreme Court Attorney Disciplinary Board versus Pamela Vandell. The last case is now submitted to the court without oral argument, and we'll now hear the arguments in the first proceeding. Mr. McCormally.
Mr. Chief Justice, and may it please the court, good morning. Gary Pettit was convicted of sexual abuse in the third degree in 2004. As a result of that conviction, the Iowa Department of Corrections required him to complete sex offender treatment. Mr. Pettit appealed that classification and had a hearing before an administrative law judge. The ALJ upheld the classification. Mr. Pettit filed a petition for judicial review pursuant to Iowa Code Chapter 17A. The department filed a motion to dismiss, saying that 17A is not the proper vehicle and that Chapter 822, the post-conviction relief statute, is the way to bring a challenge to the classification. The district court dismissed that motion to dismiss, and then after the case was submitted, the district court reversed the classification decision on the grounds that Mr. Pettit was denied counsel at that classification proceeding. The state asked the court to vacate the district court's decision and remand this case for dismissal for two reasons. First, inmates do not have a right to counsel in prison proceedings. And second, Chapter 822, not 17A, is the proper vehicle to challenge a decision of the Iowa Department of Corrections. As to the first issue, the district court's decision to vacate the classification on the grounds of denial of counsel flies in the face of established precedent and the statute. And it's based on a decision of this court from last year, State versus Young, in which this court held that the right to counsel attached in misdemeanor proceedings, any case where the defendant was potentially subject to imprisonment. That holding should not be extended to prison proceedings. In the first instance, a defendant who is going to prison for the first time is situated much different constitutionally than a defendant who is already in prison. That is U.S. Supreme Court Meacham v. Fano. It's this court in State versus Salad. It's given a valid conviction.
Are you conceding that there's a liberty interest involved in this case?
I think this court has been clear that the right to earn time is a liberty interest.
Is that even challenged here? I mean, one of the challenges in this case, for me at least, is characterizing what the dispute's all about. And on the one hand, earned time is floating around, of course. On the other hand, there's a suggestion, certainly in brief, and we'll probably hear from Mr. Dickey, but the suggestion is what's really being challenged is the classification, and that his client does not want to engage in what he calls, I think, a behavioral modification, STOP. And at least arguably that's different than an earned time problem, I guess. And do you see
I do, and it has been one of the difficulties I think that both of the district courts that looked at this case struggled with. So what's really at issue here? Sex offender treatment, though, simply being classified for sex offender treatment implicates the right to earn time.
But he's not challenging that, I don't think. I mean, he claims he's not challenging that.
He's not, and what Mr. Pettit, I think, ultimately is challenging is the fact that there's this recommendation in his file that when the Board of Parole looks at it, they say, oh, he hasn't completed SOTP, we're not going to parole him. And that, I think, is where the 17A 822 thing gets muddled, right? If this was a challenge to the Board of Parole, 17A would clearly be the vehicle for it. It's the Department of Corrections classification. Where I think this becomes a lot simpler is in the fact that Mr. Pettit is a sex offender. And simply by being a sex offender, he is properly classified for sex offender
Well,
treatment.
let's back up a second, though. You know, in Dykstra, where he was not convicted of a, quote, sex crime, but there were sexual overtones to his criminal act, we held there's liberty interest, and there's a due process right of the prisoner to challenge the requirement that he take SOTP, and we gave him 4 different rights, notice, hearing, things like that. And you don't disagree with that.
Absolutely not. I think that's Wolf versus McDonald.
And when I read your brief, I mean, you stop there in this case by saying because he was convicted of a sex crime, he's not entitled to those due process rights because he had those at the time of his conviction, including right to counsel. I mean, do I read that right?
Well, I think this court actually said something very similar, actually, even in the Dykstra case, when it quoted the Ninth Circuit in Neal versus Shimoda, and it's saying that an inmate who's been convicted of a sex crime in a prior adversarial proceeding has been given the minimum protections.
And I know we said that, but here's my question. Say this was a Dykstra case where he hasn't been convicted of a sex crime, and the defendant is challenging the SOTP order, or the warden's order to take SOTP, or the prison's order. In that case, we said it's liberty interest and you get 4 rights. Does the Iowa Constitution and Dykstra add a 5th right, right to counsel, and if it does, why? If it doesn't, why not?
Sure. Thank you, Justice Wiggins. That clarifies your question for me. I don't believe the right to counsel attaches in a prison proceeding, period. From the point that liberty interests in prison arise when we've got, the Sandin versus Connor atypical hardship, or when it's going to inevitably extend the duration of the person's time in prison.
Said in Dykstra that there was a liberty interest involved. So following up on Justice Wiggins' question, if you had a Dykstra-type case where the offender is convicted of an offense that on its face is not a sex offense, but yet there are sexual overtones and the prison believes that sex offender treatment is appropriate, under Young, does the prisoner have a right to counsel in the classification hearing?
No,
Why not?
because the inmate has already been constitutionally deprived of his liberty to the point that the prison can confine him to the rules of its system. But please let me finish, because I realize that is a bold statement. Here's the distinction between this case and Dykstra. Mr. Pettit obviously was convicted of a sex offense. Last year, I think it was 2014, the Iowa Court of Appeals issued a decision in State versus Lindsay, which is a case involving exactly this situation. It was a person who was originally charged with a sex crime and then also charged with domestic abuse. Through the course of the plea deal, the sexual charge was dropped. Mr. Lindsay went to prison on a domestic abuse charge. DOC classified him for SOTP. Mr. Lindsay challenged that classification, and the Court of Appeals said you cannot rely on the unproven charge, the unadmitted allegations, to require somebody for SOTP. We asked for further review of that holding, and this court turned us down. But I think the fundamental idea that comes from Lindsay is that the situation where an inmate is classified for SOTP without having been convicted of a sex crime simply doesn't work anymore. And I don't want to concede that without having argued that case, but that's been the position that Lindsay has left the department in, is that individuals who are not convicted of sex crimes, without the benefit of calling in witnesses and providing a full administrative hearing, I think that's where Lindsay leads us, that without witnesses and subpoenas and perhaps the right to counsel, we can't classify people for SOTP unless they're convicted.
Have
of
another pending case on that issue?
Yes, yeah, and
So let's not presume how we're gonna decide that case. Getting back to it, I didn't join Young, but Young seems to me to say that if you have a deprivation of liberty, then you have a right to counsel. And so why doesn't that apply here? If it's someone who's not previously been convicted of a sex offense.
if it's someone who has not previously been convicted of a sex offense, in order to provide that inmate with the maximum due process protections, right? I think then we have to go to what process is due to inmates in prison and the balancing, the sort of Matthews v. Eldridge balancing that happens.
But that's a federal test. We said in Dykstra what the federal due process requires under the balancing test. The question becomes, what more does the Iowa Constitution require after Young?
Sure,
And
and
that's the issue. The balancing test is one thing, but where does Young leave us under the Iowa Constitution?
And I think that Young should not apply to proceedings in prison because the nature of the liberty interest is fundamentally different. When someone has already been convicted of a crime and they've come to prison, there are certainly, there's a different standard of proof, there's a different set of procedures that attach. It is simply not the same scenario as somebody who is facing going to prison for the first time. That is
Yeah,
what,
but Young applies to civil cases if Young's right. And in civil cases, if there is a liberty interest, which the United States Supreme Court has found and which we agreed with, why doesn't it attach to protect that liberty interest? Unless you're gonna say it's liberty interest for the federal Constitution but not for the state, and I don't know how you make that distinction.
no, that's not, and I think what this court said in adopting, I think about Sanford versus Modernock, where this court did apply that Matthews test to prison proceedings, right? And we're talking about what's the interest at stake, what's the risk of erroneous deprivation, and then finally, what's the government's interest, right? And I think in considering, are we gonna add a right to counsel to prison proceedings? And I think we need to be clear, if we're gonna allow it here, I think there's no limit to where that right needs to be.
But we've added it to misdemeanors, where there's a right to prison. I mean, that's way far beyond what the United States Supreme Court has and what the United States Constitution requires. And you can say that makes it unwieldy and it makes it difficult, but constitutional rights are difficult and are unwieldy, and that's why they're there. They're a bar or a hurdle that the state must pass in order to get from A to B.
Sure, and I think it breaks down here. If you're gonna extend it in the Dykstra-like case, I think then you also have to extend it to any case where earned time is at stake. So anything under 822F. So there's a statutory prohibition, well, not prohibition, but statutory bar to counsel in 822-2F, that we don't pay for costs for inmate disciplinary hearings. I think if you're gonna extend Young.
Well, no one said who's paying for the counsel. That's a different issue. The question is, does he have a right to counsel at his own expense? You have a different question, and they're not asking for at their expense. The question is, do you have a right to counsel? Can he go hire somebody, or can someone do it pro bono for him?
One of the things that this court has said in cases where the issue of counsel in prison proceedings has come up is that it goes right to the heart of the difficulties in administering prison disciplinary cases and the massive volume of cases that these are. Extending Young to the prison scenario extends it to every, challenge to loss of earned time, every disciplinary decision.
Yeah, I share that concern, but give me a reason based on Young why it wouldn't apply to prison proceedings.
Because the liberty interest at stake in Young is of a different nature. It's a different kind of interest than the interest of somebody who is already in prison. The person who's already in prison has had their liberty deprived constitutionally through due process.
Can I ask a question? Your time is running out, but the jurisdictional issue is one that I'm struggling with, and it looks like everybody's struggling with a little bit. There's no question that 822 generally is a vehicle for disciplinary actions, and I think everybody concedes that. But this, and just looking at one of the provisions of 903A3, it talks about inmate disciplinary procedure, including but not limited to awarding and forfeiting earned time, is not a contested case subject to 17A. But once again, I'm not sure that principle applies in this case, in part because of the characterization that the party puts on it. He says, "Look, I'm not really challenging the lack of earned time, but I don't want to go through behavioral modification." I mean, I'm paraphrasing, of course. And if we accept that characterization, where does that leave us in the jurisdictional issue? Does that make it a 17A claim, or does it still, I mean, how do we, it seems you're forcing it into 822 a little bit, because it's not really a disciplinary action.
Justice Appel, my time has expired. May I answer briefly? In the first place, I don't think you should accept the characterization that that's not really what he's challenging. If he's not challenging that, then I would say that then he doesn't really have an interest that he is challenging. If he's not challenging earned time at all, then this issue probably isn't ripe until he suffered the sanction of losing earned time. But in terms of forcing it into 822F, I guess I would liken it to the fact that earned time is implicated here at all, that Holmes says that there is a right to have the right to earn time. Then you've got this sort of falls under the penumbra of 822.2F, that earned time might not be an issue immediately, but it's what we're concerned about in terms of the liberty interest going forward. Thank you.
Thank you as well, Counsel. Mr. Dickey.
Mr. Chief Justice, and may it please the court, I'm Gary Dickey from Dickey and Campbell Law Firm in Des Moines, appearing on behalf of Gary Pettit, asking this court to affirm the district court's decision and reverse the department's classification requiring Mr. Pettit to undertake sex offender treatment programming. Question presented in this appeal is whether that classification determination by the department is a case, quote, involving life or liberty of an individual. If it is, then Article 1, Section 10 of the Constitution guarantees Mr. Pettit a right to counsel in that proceeding. If it does not, Mr. Pettit still prevails because the department lacked both a legal and factual basis to require sex offender treatment programming for Mr. Pettit based on the individual facts of his case. With respect to the constitutional issue, I guess I want to clarify what is and what is not being challenged here. Mr. Pettit did not refuse to participate in sex offender treatment program because the potential cost of doing so and being wrong about the classification determination would have resulted in a loss of all of his earned time. So this is not a situation where he has refused to participate or that he has lost earned time. Rather, he's challenging the initial classification to require him to do that.
Yes, but if you read the notice by the prison is quite clear. It says, this classification decision may affect your future accrual of earned time and tentative discharge date pursuant to Iowa Code 903, they cite the Iowa Code section. Now, he's making this argument, well, I had it before, so I don't have to do it again. But the effect of that argument is that if he loses that argument, he loses earned time.
Correct.
I mean, so the whole classification argument, the bottom line is that if he loses earned time. I mean, that's the bottom line, no matter what excuse he has. So why doesn't this fall into 822? Because the whole controversy is over earned time.
Because by the clear text of 822, if you look at F first, that is following a prison disciplinary procedure by its terms that results in loss of earned time. 822 point, I think it's 3F, does not apply because there's not been a prison disciplinary proceeding at the conclusion of which he lost earned times. So that leaves only subsection E, which is a deprivation of, continued incarceration. And there's no question they have a right to incarcerate him. He was convicted and sentenced to incarceration.
But if you read 903A34, which Justice Appel just said, it says if the controversy's over, I read it saying basically if the controversy's over in time, it's not a 17A action. I mean, you could frame the issue any way you want, but the bottom line is it's whether he loses earned time or not. And if you read McGee, I don't know if I'm pronouncing that right, when Justice Turnus went through 17A versus 822, she seemed to say at the end that it's probably better that 822 applies. And, she has that footnote, which is a footnote, and it really doesn't explain what she meant. But when you read the case entirely, the last part of the case says this should be 822. And it seems to me that you're trying to reframe the issue in order to avoid the 822.
Okay, so I want to be clear on, with respect to the 17A issue, the rule as I understand it from McGee and this court's jurisprudence is 17A applies unless there's a more specific statute. In this case, the state asserts that 822 is the more specific statute. Just textually on its face, the plain language, it does not apply. Now, the reason we went through 17A is so we could get a determination based on the merits from the district court much sooner than under 822. Frankly, I don't understand why the state wants to go under 822 with the deference that they receive under 17A.19. But that's the argument they want. As a practical matter, the only reason we wanted to pursue 17A is because in Polk County, to avoid the lengthy discovery and getting a trial date, which could be as long as a year for an 822 case, we wanted to short-circuit it so that Mr. Pettit could be available for parole with a correct determination on the merits. Now, as that relates to the constitutional issue, the classification decision as opposed to the deprivation of credits implicates a physical liberty interest in three respects, and those are the respects that
Let me interrupt you for a second, I'm sorry again, but do we even get to the constitutional issue if the court had no authority to hear the case under 17A?
Well, I think there's a rule that allows a district court, certainly the Court of Appeals or the appellate courts, to reframe a case that's not pled correctly. So if it is an 822 case, then remand it down and we'll consider it under 822.
But how can you redo it under 822 if you have even the wrong party? Because a post-conviction relief action is brought against the state of Iowa. You brought your action against the Department of Corrections. So it's not even captioned properly, and if you read your petition, it's all under 17A. So, we convert certioraries and things like that, but I don't know how, tell me what authority we could convert this. The rules allow us to convert those other ones, but where do the rules allow us to convert a 17A to a post-conviction relief action when the parties are even different?
Well, I guess what this court has said is 17A applies unless there's a more specific statute. And if the court wants to hold that a classification decision that the result of which doesn't result in any discipline or earned time credit loss is an 822 action, then that's what the court holds. But
if you find that he has to take this SOTP because the SOC wasn't the same, he ends up with earned time credit lost.
No, because he what the state does is puts him at a false choice here. You can refuse to do it, and now the department's position is you lose all earned time ever accrued, not just from that point forward. So the risk of challenging it and being wrong is so great for inmates that as a practical matter, they're not refusing to participate in SOTP. So the only way to effectively challenge the classification decision is before the point at which you lose earned time.
But then is it really ripe, or is it moot because there's no loss of earned time in the darn thing?
Well, I mean, this court's rightness doctrine is that if there's a real prospect of punishment, that you shouldn't require a party have to actually be punished before they can challenge it. And I don't think there's any dispute here that if Mr. Pettit would not have participated in SOTP, he would have lost earned time credit. That's in the notification itself. So with respect, turning back to the constitutional issue, with respect to the physical liberty interest, the interest that we present is the same that was identified in Dykstra, which is three parts. One is the stigma associated being with required to participate in SOTP. The second is the behavior modification aspect of the treatment that he would be required to do, in addition with that being used against him by the Board of Parole, refusing to grant him a parole on the basis that he hasn't complied with treatment, which he submits.
He got denied parole for a whole bunch of other reasons. I think there were 3 the last time, in December of the last parole hearing. Treatment was, well, he didn't say he wasn't SOTP. He said he didn't avail himself of all the stuff available at the prison, that his attitude was bad, and that the crime was such that he didn't. So it wasn't just the treatment, as I read the Board of Parole decision.
Well, they gave him a DRC-7 and a DRC-14, and if you look at Sonia Leib's, her testimony or answers to interrogatories, I think it's beginning 234 in the appendix, and she was his treatment counselor. We asked what was the factual basis to support those, and certainly she takes a different view as to whether or not there was a factual basis. He's a low-risk offender. There was no diagnostic need for any type of treatment, and
Shouldn't you appeal to do a 17A in the Board of Parole rather than look behind the Board of Parole hearing? I mean, the hearing, if the order wasn't challenged, so we have to believe the order is correct.
But the Board of Parole appeal process doesn't allow me to go back down to the Department of Correction agency level and challenge their recommendation to the Board of Parole because it lacks any legal or factual basis. So this was our only avenue of doing that.
You know, as I read McGee, that seems to stand for the proposition that 822 and not 17A is the proper vehicle to use if the prisoner has been moved from one part of the prison system to another, from one program to another. Why doesn't that logic and that reasoning apply here, where your client is saying, maybe I wasn't moved from one part of the prison system to another, but I was forced to take an additional program that I didn't want to take? Why doesn't that simply fall within the logic of McGee?
Well, again, the only basis under 822 is if there has been a reduction of credit as the product of a disciplinary proceeding, which is not the case here, or, and I'm going to quote subsection E, the person is otherwise unlawfully held in custody or other restraint. And reading that just textually doesn't seem to apply.
So are you asking us to overrule McGee?
No, McGee is the situation where you have an offender who refused to participate and then was disciplined and lost earned time. Mr. Pettit hasn't done that, because had he done that, the risk of losing would have been to lose all of his earned time ever accrued over the 11 years of his incarceration. The only basis for him to challenge without involving 822.3 is to challenge the classification decision itself, which under Dykstra implicates a physical liberty interest, which requires the appointment of counsel.
Well, let me tell you where I'm struggling with this, because I'm not sure that this, to me, seems to be the appropriate vehicle in order to expand this right to counsel in this setting. And the reason I say that is there was never a question that he was going to be classified and was going to be required to have sexual offender treatment programming. And so that's back in, 2005, whenever his conviction was. There was never a doubt about the classification, that he was going to be classified and was going to be required to take that. The whole issue now is when he comes up for parole 9 years later, they say, well, the SOC, sex offender counseling, does not equal sex offender treatment programming, so we're not going to consider you for parole. And so to me, the whole argument here is not a classification. It's not, you have to do this or you're going to suffer the deprivation of earned time and all these. The question is whether these are synonymous type of programs, and the decision is simply no, it's not. You have to take the actual self-offender or sexual offender treatment programming. So I don't see that this is going back to the classification. There isn't hanging over your head a deprivation of any type of earned time. You know, you just have, is this equal to that? And so I don't see that as, frankly, I don't even see it as a liberty interest under those sets of circumstances. And so I'm anxious to hear.
The history of Mr. Pettit's conviction and the timing of all of the statutory changes is important because Mr. Pettit was convicted in June of 2004. So as I recall, the amendments would have taken place in 2004, July 1st. So he's before the 2004 amendments. There's no, in the statute, it does not require per se that he takes sex offender treatment program based on the nature of his conviction. Rather, what the statute says is that the Department of Corrections Director will promulgate rules as to who participates in sex offender treatment program.
Didn't we already decide that it did have that effect anyway to anybody in his situation? That the change in the statute, which I think happened in 2005, you may be right, 2004 or 5, after his conviction, haven't we already said that it still applies to somebody in his situation?
That's not how I read Vallon, which says that over the passage of time, that there may, and McGee or Dykstra suggests this, that there may be instances in which the department's determination of whether a person requires SOTP is subject to review. And this is that situation because we have a conviction that is 11 years prior to the time where he is required to take SOTP. There's no therapeutic need for him to take it based on Sean Crawford, the medical treatment director's own testimony. Nobody's established any type of a safety risk. So the whole purpose of SOTP is to identify those offenders who need rehabilitation and pose a risk to the community. And there is nothing in this agency record that suggests he meets either of those criteria.
So is it something that we're going to now attach a right to counsel on these type of review processes then? Is that what you're saying? Because now it's like, are we saying it goes back to like an original determination?
Well, I'm not sure that question is presented here. What I would tell you is the analysis would be the same, and that is if it is a case that involves the deprivation of a physical interest, then under Article 1, Section 10, there is a right to counsel. And so, granted, that will require this court to confront the issue in a lot of different prison settings, but in order for us to stay faithful to the text and the history and the purpose of Article 1, Section 10, that's the result that's required. I would point out one last thing, and that is Mr. Pettit did take sex offender counseling, which for all intents and purposes, except for the polygraph, is the same. That's a factor the department did not take into account, and the treatment director couldn't even articulate what that programming was. So for those reasons, we ask for the district court to be affirmed.
Mr. Dickey, would you have brought this action under 822 if the time to process it would have been compatible with 17A?
Yes. Because Mr. Pettit was in prison under the belief that the parole board would have given him a favorable recommendation had SOTP not been required, we were looking for the fastest relief possible, and the decision was under 17A.
Thank you, Mr. Dickey. Mr. McCormally, a rebuttal argument?
Chief Justice, just to your last question, one of the things about 822 that makes it different than 17A is that challenges to decisions of the department and the prison are brought in the county of confinement. So Mr. Dickey mentioned he wanted to bring this case in Polk County. He's free to plead his case how he wants to, but I can tell you that had he brought this case in Henry County or in Jones County or in Jasper County, where the sex offender treatment program is now located, the timing would have been similar. It's one of the benefits, I think, that those counties where the prisons are located are used to the volume of SOTP and 822 cases. So that's, I think, a reason why 822 is a better vehicle than 17A is for this. I wanted to talk a little bit about the factual basis of requiring someone for sex offender treatment. Mr. Dickey brought up the Vallon case, and this is a very different case than Vallon. Mr. Vallon was someone who was convicted of a sex crime, got out, got picked up again on an OWI some years later, and they required him to complete SOTP as a condition of probation. And what this court said in Vallon is that there's not a sufficient nexus to identify a problem currently suffered between his OWI conviction and sex offender treatment. That's not what we have here. Mr. Pettit is in prison for a sex crime. And if you look, to the language of, say, the DSM, where they talk about treatment, a problem currently suffered means something that's causing somebody interpersonal distress. Being in prison is a treatment need. So simply by the fact that Mr. Pettit is in prison on a sex offense is sufficient to require sex offender treatment. With respect to classification, this court decided 3 SOTP cases on the same day in 2010. There was Dykstra, there was Riley, and there was Waters, and they all implicate a little bit different part of this process. Dykstra, we've talked a lot about it. It involves the offender who was never convicted of a sex crime who was required to take SOTP. Riley talked about the due process due to somebody who is removed from SOTP. But Waters is the one that sort of it's stuck in the middle between the two that doesn't get talked a lot about, but I think it's really important here. Mr. Waters was in prison for an OWI and a sex offense at the same time. And his sex offense had discharged at the time he was required. And this court said that it is still okay to require him to complete SOTP because he came to prison on a sex crime. So even though he wasn't even currently serving a sex offense sentence by the way the time comps all ran, SOTP was still appropriate. This is where Mr. Pettit's situation is most comparable, is that this is somebody who's in prison on a sex offense who's required to take sex offender treatment.
Raising different arguments than were raised in those 3 cases. So I asked the question to Mr. Dickey, do we have to overrule McGee? Is there a difference between a decision that, a prison decision that moves a prisoner from one program to another, one institution to another, apart from sex offender treatment, and a decision to put him in sex offender treatment? Are they all the same?
At least with respect to the things that have been identified here. So McGee talked about something that is very specifically enumerated, right? The work release revocation is something that's talked about in 822. Here, because the earned time is at least implicated, 822 should be the vehicle. Even if it's not a direct challenge to the loss of earned time, it's the idea that earned time could potentially be at stake. That's really the liberty interest that's at the heart of this case. And so because of that, again, I'm going to go back to the word penumbra, that's why 822 is the vehicle. I don't think it requires to overrule McGee. I think McGee is correct, is that 17A controls judicial review unless there's a more specific statute. And for the Department of Corrections and the decisions made by prison administrators, 822 is the more specific statute. And I'm sure there might be a situation where we could come up with it that 17A would be potentially the vehicle. I haven't been able to think of one because every decision of the prison that I've been able to think about involves the at least potential for somebody to stay in prison, and that falls under 822.
I guess, if I may, Chief, I mean, here's where I'm confused. Do you even need to have, as I read the language in McGee, it's very broad, and it seems to say that any transfer from one institution or one program to another, it doesn't focus on the potential loss of earned time. It simply says if the prisoner is moved from an environment he or she wants to be into an environment that is less desirable, then that's sufficient to fall within 822. Am I reading it wrong?
I think that's correct. I think it goes back to the idea of what are the liberty interests at stake, and does it fall under those Sandin versus Connor type issues? My time has expired. Thank you.
Thank you. The case is submitted, and we'll next hear the arguments in State versus Roby.